Alright, once again, I'm sorry about the hum in the background. It feels really loud this morning as far as the hum goes. It's nothing to do with the microphone, it just has everything to do with the room that I am in. So all that is going to be influential, but as far as things that we talked about, this is coming a couple of days late, but in civil procedure, we finished talking about domicile underneath the heading of diversity jurisdiction. And as you remember from last time, diversity jurisdiction is outlined in 28 U.S.C. 1332. The two essential parts of diversity jurisdiction is going to be the domicile and the amount of controversy. And what we had talked about previously for domicile was domicile for individuals. And we used Gordon v. Steele to talk about that. Talked about minimal diversity and complete diversity, the difference between those two, and how Section 1332 requires complete diversity in order for a federal court to hear the case. And now we're getting into a couple of other topics concerning domicile, and we're going to look at how corporations are viewed with their domicile when it comes to diversity jurisdiction. And then we're going to talk about how U.S. citizens residing abroad are treated underneath Section 1332, as far as when courts can hear their cases. So there's all that. As far as corporations go, let's just go ahead and finish up domicile corporations and then the U.S. citizens residing abroad. Corporations, we have Hertz Corp versus Friend. And what happened in this case is that there was a wage conflict between Hertz and Friend. Friend is located in California, and Hertz is a nationwide company, but they were incorporated in Delaware, and their headquarters was in New Jersey. And so we're trying to figure out whether or not Friend can sue Hertz in a federal court, and that's what this whole conflict is going to be about. Before I get into any further details of that, I need to note that there is a difference between general personal jurisdiction for domicile and diversity jurisdiction for domicile. General, we'll look at the state of incorporation, the principal place of business, and essentially at home. Diversity is going to exclude the at home and only focus on the state of incorporation and principal place of business. Hertz, this case, is going to be trying to figure out how we define principal place of business. And principal place of business, the court says in Hertz, and has been adopted by pretty much every other jurisdiction, the principal place of business is going to be the headquarters. It's going to be a single location that's where all the general information about a company is going to come from. All the direction is going to come from the headquarters, the principal place of business, which instructs other parts of the company on how to conduct their work. The reason why this was brought up in Hertz is because Hertz, even though its headquarters was in New Jersey, the majority of its business, the place where most of its sales came from, where it employed the most amount of people, was all in California. And this all makes sense because California is one of the largest employers. I mean, it's the most populous state. And so it's going to make sense that a lot of things are going to come from California. And so what the plaintiffs are arguing here is that the principal place of business should be the place where most of the business is conducted. And the court disagrees, and they say that no, we're going to focus on one singular place, and that singular place is going to be the headquarters of the company. And so in this case, there was no diversity jurisdiction. Actually, there was diversity jurisdiction. Hertz was originally sued in a state court, and they wanted to be removed to a federal court. And so we're seeing if it can be removed to a federal court. And the court is going to say yes, it can, because there is diversity. The principal place of business is New Jersey, and the plaintiffs are from California. Those two are different on both sides of the verses, and so there is diversity. I want to just sum up everything I said because I didn't say it in the most organized way. Corporations, we're going to look at principal place of business and the state of incorporation. If they are diverse in both of those ways, then there can be diversity jurisdiction. Principal place of business is just going to be the headquarters of the business, and this is called the nerve center test. The only exception to this is if the headquarters, quote unquote, is used fraudulently, and then the courts are going to look at other potential communication coming from leaders. One final thing to note with corporations is that this applies to corporations. Partnerships, as we talked about the other day, are still going to be looking at the domicile of every single one of its partners. Alrighty, let's look at U.S. citizens residing abroad. Our case for this is Redner versus Sanders. Excuse me. The thing to note about Section 1332A2 is that diversity jurisdiction, the courts can hear cases from U.S. citizens suing foreign individuals, meaning if there's a person in another country, residing in another country, and a citizen of the other country, well, then they can be sued. However, if it's a U.S. citizen residing abroad, Section 1332 doesn't say anything about whether or not those people are diverse. And so the courts can't hear those cases because the absence of that authorization really just means that there is no jurisdiction that they can hear it. So we're talking about U.S. citizens that are domiciled abroad. Remember, domiciled is physical presence plus an intent to remain definitely. When it comes to examining foreign domicile, let's just say in most situations we can use domicile and citizen interchangeably. But when it comes to saying that foreign domicile, we can't use the word citizen because, well, they aren't necessarily a citizen of that state. And so instead we're going to use the word resident. So if it's in the United States, domicile and citizen are interchangeable. If it's foreign, it's going to be domicile and resident are going to be interchangeable. So what happened in Redner versus Sanders? Well, plaintiff in France, a U.S. citizen residing in France, has sued a company. I believe the company was in New York. And this failed in the lower courts because she was, or he, I can't remember exactly who. But anyways, because there's nothing in Section 1332 about U.S. citizens residing abroad being able to sue in a federal court, that means that diversity jurisdiction does not allow them to hear those cases. This is not necessarily the case, though, if, for example, they were residing abroad but have made it back to California, and so they're trying to establish that their domicile was California and suing a New York plaintiff. The court disagreed with this because, well, there was nothing tying them to California. Well, there were plenty of ties to California. They were originally from California before moving to France, but they had been in France for a decade, and they had plans to move back to California, but they had not yet moved back to California. Consequently, their domicile has not changed because even though you have definite plans to leave at that point, your domicile hasn't changed until you've established physical presence in that state. So consequently, Redner did not have diversity jurisdiction because technically they were still domiciled in France. So U.S. citizens residing abroad cannot meet diversity requirements unless if their domicile is coming to the United States. This is kind of the opposite, though, of foreign citizens residing in the United States. For the purposes of foreign citizens residing in the United States, they are considered citizens for domicile purposes only of the state that they are currently residing in. So say somebody comes from Canada to Kansas, you're from Iowa, and you see that person in Kansas. Do you have diversity jurisdiction in that case? And according to Section 1332A2, you do have diversity jurisdiction. And it's because it gives you that authorization. It is express authorization, whereas U.S. citizens residing abroad do not have that express authorization. And so that finishes up domicile. And next week we're going to be getting into amounting controversy as well as a couple other topics. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.